Good morning, all. This is Nina Olson with the Center for Taxpayer Rights, and it is my distinct pleasure to open another workshop. This is our fifth workshop in the series Reimagining Tax Administration Social Programs Through the Code. And we have a stellar panel here today that will be addressing the topic of due process and taxpayer rights in the administration of the EITC, the Child Tax Credit, the Advanced Tax Credit, and then taking a look at the protection of rights and due process in other benefit programs in the United States to give us some context to where tax administration fits in. And as you know, we've had 4 panels before this that have led us through the roadmap, sort of understanding where the IRS processes are today, taking a look at the EITC, CTC population and their demographics and other characteristics, then taking a look at the administrative burden, particularly as it impacts persons with those characteristics, and then coming back and looking at the EITC, Advanced Child Tax Credit, eligibility rules and comparing them to eligibility rules for other family benefit or child benefit programs, not just in the United States, but even internationally. So that brings us today to talking about due process. Once you're in the system, how are your rights protected? What rights do you have? What's constitutionally required? What should be done anyway? Little d, little p, due process. Our next panels will be something that keeps popping up every time we have one of these sessions, which is the culture of the IRS and the organization of the IRS itself. And so next Monday, we'll be having a panel on that, and we'll wrap it up with a panel with recommendations for change. So with that, I'm going to turn it over to Anna Gooch, who is the research fellow at the Center for Taxpayer Rights, who is our moderator. So Anna, go ahead.
Thank you, Nina, and thank you for having me here. So before I introduce our panel, I just want to very briefly, especially for our non-lawyers in our audience, just give very high-level overview of what we're talking about, what, as Nina put it, capital D, capital P due process is. So again, very high level, the 5th and 14th Amendments require due process before the government can deprive someone of life, liberty, or property. We're generally speaking about property, but what does that mean? What is due? So very broadly, again, we're talking about notice. What is the required notice before the government takes something from someone? Is that person required to have a hearing, an opportunity to be heard, and in what forum? So that's just sort of what we're talking about today. And we'll first talk about that in the tax context and, how does the tax system do things? Why does it do it the way that it does? And then we'll switch over and look at examples in a non-tax context, and we can sort of compare the two. So that being said, I'm going to introduce our panel, and I hope they forgive me. They're also accomplished, but I cannot list all of their accomplishments in the time we have. So I will introduce them quickly. So first we have Susan Morgenstern, who is the Acting Supervisory Attorney Advisor for the National Taxpayer Advocates Attorney Advisory Group. Previously, she was a senior attorney with Legal Aid Society of Cleveland, where she founded and directed the low-income taxpayer clinic there. And then we'll go to Professor Les Book, who is a professor of law at Villanova University, where he focuses on procedure and administration in both the law school and the graduate tax program. And in 2019, he served as a professor in residence with the Taxpayer Advocate Service with Nina. And then for our sort of non-tax side of things, we have Jen Burdick, who's a supervising attorney at Community Legal Services in Philadelphia, where she works with the SSI unit. and she represents people seeking SSI benefits and advocates for systemic reform at SSA. Recently, however, and we're so lucky for this, Jen has moved into the tax arena, and she's working on ensuring that tax refunds are accessible to SSI recipients. And last, but certainly not least, we have Manasi Deshpande, who is an assistant professor of economics at the University of Chicago, Kenneth Griffin Department of Economics, and a faculty research fellow at the National Bureau of Economic Research, where she focuses on the optimal design of social safety net programs and their effects on consumption, health, and well-being. So we will address questions at the end, but if at any point you have any questions for any panelists, feel free to put them in the chat and we will be sure to get them answered. So there's a lot to cover today, so I am just going to go ahead and turn it over to Susan, who will talk about the IRS and the processes that we will sort of be working within today and for the rest of the workshop series.
Great. Good morning. Thank you, Anna. Thank you, Nina. This is really an honor to be with you this morning. Thank you for the invitation. I'm going to start with a disclaimer. As a government employee, I'm going to give you this disclaimer, which is that I am speaking in my personal capacity. The views expressed today are my own. So I'm going to talk about math error processing. And math error processing is this expedited way of summarily reviewing a return and saying you owe more money. But I thought first I would start with some background and talk about what it means to assess a tax and generally how the IRS goes about interacting with taxpayers. So, 20 years ago, I started doing tax law and I thought, oh, this is going to be pretty straightforward. You file a return, you get the earned income credit and you call it a day. And I was very, very, very wrong. And I'll never forget the first letter I got from the IRS with regard to a client of mine, and my hands were shaking so much I could barely open the envelope. And what was in the envelope? This was a regular exam, and the IRS wanted to interact with my taxpayer, with my client, and ask me a bunch of questions about her entitlement to the earned income credit. And thus ensued a written dialogue with the IRS about, did the children really live with her? Did she really support the household? And it was back and it was forth, and mostly not a very satisfying experience, because the last thing I got before we left the IRS was a notice of deficiency. And I'm talking about this case because I want to explain how in regular deficiency proceedings, there is this opportunity for interaction between taxpayers and the IRS. So this all begins, it's a correspondence-based communication system. The IRS sends a letter saying we have some questions about your return. You respond, the taxpayer responds, generally within 30 days, and the IRS takes a look at the response and says, okay, this is great, or the IRS, and we're going to allow your return, or the IRS says, maybe not so much, and sends back a report. And then the taxpayer can then interact again with the IRS and say, well, here's some more proof, or here's why I'm taking the position that I'm taking. The IRS then writes back and says, okay, great, or the IRS writes back and says, okay, not so great. And then the taxpayer can seek appeals review, and ultimately the taxpayer will get a letter giving them 90 days to petition the tax court and say, and have a trial on a 1040. I mean, this is, when I first started doing this, I thought this was unimaginable. Why would people want to have a trial on a 1040? Until I got that first case where I said, I have to have a trial on this 1040, another opportunity to present my client's story to a judge to talk about why it is that these children resided with my taxpayer as she claimed them. So it's again, I talk about this experience because it really was an opportunity for this give and take to understand exactly what was going on in my client's life, for her to understand what the IRS was inquiring about, and for us to understand what it took to present her claim ultimately for benefits. The IRS also has this other process, and this is the process of math error assessment. And math error assessment is really this sort of summary assessment process. And it's found in Internal Revenue Code 6213, and it gives the IRS the pre-refund authority to adjust an account or summarily assess a tax. And in the exam context, there is also this pre-refund authority and opportunity to interact with taxpayers. But again, you have the benefit of this prolonged interaction. In the math error context, you do not have that opportunity for prolonged interaction. This was, as the name suggests, was originally designed to address computational errors in tax returns. Remember back in 1926 when this was enacted, we didn't have computers. We didn't have calculators. We really had 10 fingers, and it was possible to make these computational errors. And that was the advantage of this math error, is the IRS can come in and say, there's this addition issue or there's a subtraction issue, you didn't do it quite right, so let's fix it. And that was how math error was born. Over the years, math error assessment authority has been expanded to address certain clerical errors, and this would be inconsistent entries on a tax return, or perhaps information was omitted from the return, and the IRS would write to the taxpayer and say, okay, well, we're going to make this change, so there you go. So how does the taxpayer know about math error? How do they know that their return is being changed by the IRS from the return that they had submitted? Well, IRS is very correspondence based, and so they will issue a letter to a taxpayer and say, we're not giving you what you sought on your tax return. Instead, we're going to adjust your return, we're going to correct your return, and as a result of these adjustments and corrections, as IRS perceives them, you now have either a balance due, meaning whereas you thought you were going to get some money, you now owe some money, or they may correct the refund so it's a lesser amount. These notices are computer generated, and there are more than 800 different notice codes that the IRS can insert in a math error notice. So imagine it's like a fillable document, and there are 800 potential paragraphs that the IRS could be putting into that letter. And I'm gonna read you some examples because I look at these 800 paragraphs and I think, I'm not sure I understand what the IRS is asking for. So an example in the EITC context is, quote, we didn't allow the amount claimed as earned income credit on your tax return. Information on your tax return indicates that you don't qualify for this credit. Now, let me ask you, if you got this letter in the mail, would you know what the IRS is talking about? I wouldn't. So I would want to pick up the phone or write to the IRS and say, I don't know what you're talking about. Then another EITC paragraph. We didn't allow all or part of the amount claimed for earned income credit on your tax return. The information you provided on Schedule EIC earned income credit shows one or more of the qualifying children didn't meet the age requirement for the credit. Well, and you might get this letter, scratch your head and say, well, which child are they talking about? Another paragraph. We didn't allow part or all of the amount claimed as the earned income credit EIC on your tax return. For one or more of the children listed on your Schedule EIC earned income credit, the Social Security number was missing, the last name doesn't match our records or the records provided by the Social Security Administration. Again, you're scratching your head and you're thinking, which child are they talking about? What information did they get from Social Security? And finally, another paragraph, we didn't allow the amount claimed as earned income credit, child tax credit, additional child tax credit, credit for other dependents, and or American Opportunity Tax Credit on your tax return. We have no record of receiving a Form 8862, information to claim certain credits after disallowance. You must submit a completed Form 8862 to recertify your eligibility for any of the claimants, for any of the credits claimed. So you might get this letter and you're scratching your head again and thinking to yourself, why is there a need to recertify? What was the prior year at issue? If you're puzzled, as I was, as I read these letters, I think to myself, there has to be a better way. But for those of you who are curious, you can take a look at all 800 of these paragraphs. They're in the Internal Revenue Manual, which is like our internal rules. At section 3.12.3-2, and you can find the Internal Revenue Manual at irs.gov, which is our website. So what about the cost of these paragraphs, of getting these letters? In 2019, TAS reviewed 40 EITC relevant notice codes and found that for tax year 2017, 197,154 taxpayers received one of the 40 notices. Of the 40, 36,739 requested what's called abatement of the tax. And I'm going to talk about abatement in a minute. And the total amount abated was 83,886,367. So what we learned too that 36,324 of taxpayers prevailed in their claims. And what this says is that where taxpayers understood the notice and responded to the notice, that more than 99% were successful in these claims. So let's talk now about abatement. What does this mean? So when the math error notice is issued, the tax is automatically assessed unless the taxpayer requests this abatement of the tax. And the IRS must abate the tax, meaning restore the taxpayer to the position they would have been in until the issue is resolved. So the language is actually in the statute and in 6213, and it's where the statute says, a taxpayer may file with the secretary within 60 days after the notice is sent a request for abatement of any assessment specified in such notice, and upon receipt of such a request, the secretary shall abate the assessment. Any reassessment of the tax with respect to which an abatement is made under this subparagraph shall be treated to the deficiency procedure described by this subchapter. So remember what I said earlier about deficiency procedures, which is this whole opportunity to interact with the taxpayer, which ordinarily you don't get in this math error proceeding because the IRS has simply sort of used this other authority to skip ahead and just assess the tax. So there is notice provided to taxpayers about this abatement method, and it's on page 2 of this letter that had this computer paragraph on it. And on page 2 of this letter, in regular font, without any bolding around it at all, is this language. If you contact us in writing within 60 days of the date of this notice, we'll reverse the change made to your account. You don't need to provide an explanation or additional documents when you request the reversal, but we'll consider any information you provide to us. However, if you don't provide us additional information that justifies the reversal, and we believe the reversal is an error, we may forward your case for audit. After we forward your case, the audit staff will contact you within 5 to 6 weeks to fully explain the audit process and your rights, and you may need to provide an explanation or additional documents. After the audit, you'll have the formal appeal rights, including the right to appeal our decision in the United States Tax Court before you have to pay the additional tax. So you can see that it makes sense to look at page 2 of this letter, to read the small print that's not bolded, that's not set forth in any specific kind of way that calls attention to it, because that's the chance that you get, that the taxpayer gets to interact officially with the IRS about the tax return and to contest in some fashion the assessment that the IRS is making. So the abatement is the taxpayer's chance to respond to the adjustment. The response can be in telephone or in writing. If it's done by phone, I would suggest keeping good notes. If it's done by writing and you're representing a taxpayer, I would suggest sending the information in such a fashion that you can document having sent it in a timely fashion. But remember that this is the only way that the taxpayer can obtain some type of interaction with the IRS prior in order to get tax court review. If the taxpayer were to miss that 60-day abatement request period, the taxpayer could still request abatement, but it would be without the same rights that they would have had they requested in that 60-day period. So you can see that the 60-day period is extremely important. Going back to that 2019 EITC study, we found that 17,921 accounts were adjusted after the 60-day period. So you can see it's possible to request that adjustment, but if these taxpayers had requested the adjustment within the 60 days, they would have been able to have gotten to tax court, to have interacted with the IRS, and to prevail earlier in the process. Without this tax court review, the other remedies available to a taxpayer would be to pay all the tax and then file a refund claim. So for some taxpayers, this may not be a significant amount of money, but when you're talking about something like the earned income credit, the additional child tax credit, the other refundable credits that taxpayers may be seeking, this may be a couple $1,000s. And so what you're saying to taxpayers is you got to pay to the tax, and then of course you have to pay to file in U.S. District Court. So now I'd like to turn to an example from this past year, and that would be the recovery rebate credit. We'll take a look at what happened with the way those notices went out, the rights the taxpayers had along the way. So this was a new thing this year on the 2020 tax return. The IRS issued more than 5 million math error notices pertaining to the recovery rebate credit. Many taxpayers tried to call the IRS when they started getting these notices, but the level of service, and that would be the number of taxpayers actually speaking to a customer services representative, was close to 16% on the accounts management lines between January 1st of 21 and June 30th of 21. So this means that only 16% of the taxpayers who tried to reach an IRS customer services representative in the accounts management function actually got through. But first, let me give you some background. When Congress enacted Section 6428 and 6428 Cap A, it provided for an advance payment of the credit that could be claimed on the taxpayer's 2020 return. And this, of course, was the EIP that taxpayers received last year that then was converted essentially to the rebate recovery credit to be claimed on the 2020 return. Congress also gave the IRS authority to correct returns where the IRS determined that the taxpayer incorrectly claimed the rebate recovery credit. Taxpayers who received the correct earned income EIP amount, economic impact payment amount in 2020, didn't have to make any further adjustments on their tax return. But many taxpayers maybe didn't recall how much they had, disputed how much they had received. And so they put an amount on their tax return saying, this is the amount of rebate recovery credit to which I'm entitled. Those returns were reviewed by hand and by the IRS. And in response to the various claims, the IRS developed 3 different math error notice codes that it inserted into the math error notices that it issued to these taxpayers. And I'll give you the Internal Revenue Manual citation for that. That would be 21.6, 0.3, 0.4, 0.2, 0.14, 0.2. Again, this would be available on our IRS website. So here's the sample language that the IRS developed for the rebate recovery credit notices. We change the amount claimed as a recovery rebate credit on your tax return. Information on your return indicates that either you or your spouse, if married filing jointly, is claimed as a dependent on another taxpayer's return. That was notice 1. Notice 2. We changed the amount claimed as recovery rebate credit on your tax return. The error was in one or more of the following: your social security number or your spouse's social security number, if married filing jointly, was either missing or inaccurate. Your last name does not match our records. You use an individual taxpayer identification number, and there's no indication that the one spouse was a member of the armed forces of the United States at any time during the tax year, so that exception does not apply. We compared the social security numbers shown on your tax return with records from the Social Security Administration. According to these records, the SSN shown on your return for you, your spouse, or one or more of the dependents belongs to a deceased person. You must contact Social Security if this information is incorrect. And finally, the Social Security number shown on your tax return for you, your spouse, or one of the dependents listed on your return was not issued before the due date of the tax return. So that was all on one notice. And so it's like going to a buffet, like which is the reason that applies to me? And why does this reason apply to me? I don't know. So that all those notices went out, about 5 million of them went out. I'm sorry. There was one other notice that went out. And the last line in this notice is really my favorite. It is, the amount was computed incorrectly. but that's the line. It doesn't provide an explanation as to how that amount was computed, why it was computed incorrectly, and what the consequence was. What was interesting about these notices was that absent from each of these letters was the opportunity to request abatement of tax. Remember, we just finished talking about abatement. Abatement is this opportunity within 60 days to say, wait, give me some more information. So this language was not there, so taxpayers had no informed opportunity to contest the notice. Taxpayer Advocate Service advocated that the IRS must include this language regarding abatement. There was a blog that we posted on August 3rd of 2021 where you can see a greater discussion of that. And that would be at taxpayeradvocate.irs.gov. IRS agreed to correct the notices, and it agreed to issue a supplemental notice to the more than 5 million taxpayers who had received the incomplete notices. It also updated the Q&A feature on its website. It would be question G4 on the 2020 Rebate Recovery Credit page. So IRS had issued 3 different kinds of math error notices, which meant IRS had to issue 3 different kinds of correction notices. These were each tied to the reason code that had been issued, for which the original letter had been issued. So what was interesting to me about this letter was that it contained this language. This letter provides more information about your right to appeal, and I think this was the first time ever, we apologize for not providing it in the previous notice. So that was really cool. IRS apologized. And then on the first page of this in bold font, the IRS stated, to preserve your formal appeal rights, including the right to appeal our decision in the U.S. tax court before you pay any additional tax you may owe, you must contact us by phone or in writing within 60 calendar days from the date at the top of this letter. So what did we have in this letter? We had 1, an apology, and 2, we had in bold font these important taxpayer rights that had been relegated to the second page of all the other math error notices. So in summary, math error is an expedited way to assess a tax. The notices may not provide sufficient detail to explain why the IRS is adjusting a return. Remember, it's only been these corrected notices that contain the language on the front page. And otherwise, taxpayers must turn the page over and look at the font, the small font on the back. So what are we going to do about this? So I know we're going to be having a discussion later on with different people's ideas about what we can do to fix this situation. But I thought I would jump the gun and give you a couple of my ideas. One would be to move the abatement request language to page 1 of the math error notice and to put it in bold font, as the IRS has shown it can do. And second would be to ensure that taxpayer rights regarding abatement requests are included on all math error notices. And third, to implement legislative recommendation number 11 in the National Taxpayer Advocate's Purple Book, which is a compilation of legislative recommendations to statutorily limit the IRS's math error authority to clear-cut categories and to limit the authorization to use any new criteria without prior review by the Department of the Treasury and the National Taxpayer Advocate. So that is a speedy journey through math errors, and thank you.
Thank you, Susan. That's really helpful. It's especially math errors, it's such a complicated process, and I expect will only get more complicated. So with that background, we're gonna go to Les Book, who will lead us through some historical legal background of due process and where the tax system has historically seen itself in that process. So
thanks so much, Anna, and thanks, Nina, for organizing it and for the invitation as well. It's really it's a pleasure to be here, and it's so interesting. I come at this from a very different perspective than Susan and Jen. As lawyers who, they come at this from a benefits perspective initially, and I started as as a tax lawyer, in the trenches, doing tax planning work and tax controversy work. And then I, at a large law firm, then I went in and spent about a decade directing a low-income taxpayer clinic. And when I did that, my perspective really kind of changed, because I started to wrestle with what, when you experience life in your tunnel as a tax practitioner, you sometimes lose sight of the broader perspective and the broader context. And so one of those areas which has been somewhat exceptional is the ways in which the IRS and the tax system has been looked at by courts in terms of protections that taxpayers enjoy or don't enjoy. And under the kind of broad category of tax exceptionalism, that has really meant, from an administrative law perspective and from a constitutional law perspective, courts have traditionally viewed taxpayer rights and taxpayer opportunities different from perhaps others who interact with the government, and that has kind of chipped away in administrative law significantly over the course of the past 2 decades. But as I'll talk about today, the constitutional law really has not caught up in a meaningful way with changes in the tax system or with general developments in procedural due process, and that really affects the lack of protections that taxpayers have traditional or constitutional level protections that taxpayers have experienced when they deal with the IRS. And as Anna noted in the introduction, when we're talking about procedural due process, we're really talking about, at its core, risk of error, and the concern that the courts have that underlies the Fifth Amendment and the 14th Amendment in the procedural due process clause is the risk that the government may deprive of an individual of a protected interest. And in our context, we're talking about property, but obviously that extends to other, to life and to liberty. But property is generally protected, and that has afforded individuals, notice and hearing rights. And for many years, what courts focused on was whether there was an interest that gave rise to due process protections. And so again, from much of our country's history prior to the late 20th century, the approach that courts had taken in examining this inquiry or employing this inquiry was look to a mix of things like common law, history, tradition, and custom in terms of the context. So there was a very contextual base, which still is the case, but an approach that looked to try to categorize the activity in terms of determining whether there was protection and the amount of protection that was given in terms of notice and hearing. And there had been a major sea change. And again, as a tax lawyer, this was surprising to me in many ways, but for those of you who kind of steeped in benefits, this is something that many of you lived with and kind of had dear to you. But the modern due process revolution of the 1970s is, typified by some important Supreme Court cases, including Goldberg versus Kelly, which, prior to the late 20th century, there had been, when thinking about property, the focus, the focal point in terms of protection was on traditional common law concepts of property. And what the Supreme Court did in the late 20th century was really expand that to include constitutionally protected property interests, to include governmental created property rights that were beyond that, steeped in common law. So in the context of welfare benefits, there was, the court basically provided a new approach, which that, public benefits could amount to a constitutionally protected property interest. And that, and Goldberg was kind of a high water mark in terms of procedural protection, at least from the Supreme Court's perspective. it in the context of terminating welfare benefits, the court, clarified what it meant in terms of notice and hearing, but it did not necessarily provide a framework for evaluating the ways in which hearing rights or notice rights should be provided for in different contexts. So in the Matthews versus Eldridge case 6 years later, in the context of disability benefits, the court really, in a sense, cut back on or took a different approach in terms of determining the process that is due, at least in the context of the hearing rights that individuals are entitled to receive. And this familiar kind of tripartite test really sounds in a cost-benefit approach to determining the cost of the additional procedural protections versus the benefits, and that included, considering the interests at stake, both the government interests and the private interests, as well as the risk of error in the procedures that were the procedures that were challenged. And again, you could think about, the procedures can, on the one hand, be, very minimal from, kind of a paper-based correspondence hearing to, on the other end, a full-blown spectrum of a trial-like procedural protections. And so what the Supreme Court did was really provide a framework to evaluate those protections. And although not necessarily framed exactly in the same way, in an earlier case in 1950, in the Mullane versus Central Hanover Bank case, the court essentially provided a cost-benefit approach to evaluating notice as well. And that, basically looked to trying to determine whether it was reasonable, the notice that was provided reasonably was calculated to inform people of what was at stake and present really an opportunity to object to governmental action. So these are the general principles that are at play in due process. And again, there's a lot more nuance, still very context specific, but an important kind of framework. Well, how does tax fit into this? Well, interestingly enough, tax has always kind of sat in a different, in a place in the constitutional framework. And so while the approach that the court has taken to protections that taxpayers are entitled to receive is basically one that looks to post-deprivation rights, or hearing rights especially, as being sufficient in terms of from a constitutional due process protection. And so some of the procedures that Susan discussed in terms of the right, to eventually get to tax court, either in the from requesting an abatement of a math error adjustment or responding to a notice of deficiency, those rights which Congress provided over the course of the 20th century were essentially extra constitutional. They were not required, at least the courts have traditionally not thought of as tax as requiring a prepayment or pre-deprivation right to at least a judicial hearing in order to suffice for constitutional procedural due process purposes. And why is that? Well, a lot of it comes from just the history of tax. There, along, as I mentioned, the pre-Goldberg, pre-Matthews approach to due process really looked at custom and history. And since the time of, looking at back at the sovereign in common law in England, and the way that the sovereign kind of interacted with its subjects, post-deprivation proceedings were what was provided, and that was held to be sufficient. And so there are a number of cases which essentially, stand for the notion that the government's interest in collecting tax is so paramount, so important, that the notion that a taxpayer is entitled to a potential delay, or that the government is potentially going to delay the receipt of tax revenues as a matter of procedural due process protection is alien. And some of these cases arose at a time when our government was in precarious straits. So you have cases, post, right around the Civil War, at the time of our first income tax, cases really at a time where there was a concern that interposing judiciary and potentially a hostile judiciary might actually prevent the flow of revenues to the government. But so there's notion, pre-Goldberg, that tax exceptionalism, or at least an approach to due process in the context of tax, is one that looks to post-deprivation proceedings. Well, what about cases following Goldberg and Matthews versus Eldridge? And there had been at least there have been a few cases, circuit court cases, no Supreme Court cases directly on point, but the appellate court cases have essentially really rejected the Supreme Court approach in Matthews and Goldberg, and when it comes to considering the adequacy of tax procedures, at least from a standpoint of procedural due process. So cases have, essentially cite to the pre-Goldberg cases, and for the notion that post-deprivation or post-payment proceedings are adequate. And the most significant recent case that discusses this is a case out of the Second Circuit called Larson, which involved a significant civil tax penalty that was and not surprisingly, many of you today who are here are not tax practitioners or tax, start as a tax person, but not surprisingly, the Internal Revenue Code has many civil tax sanctions, some of which are really significant, and many of which do not generate the opportunity for prepayment judicial review. And the penalty in the Larson case arose from the failure to register a tax shelter, and the amount of the penalty initially assessed was over $100 million. And the taxpayer was not sympathetic, as those who peddle tax shelters are not typically sympathetic. But the taxpayer in the Larson case made a procedural due process argument, which was essentially that the inability to challenge a civil tax penalty, especially one as substantial as involved in Larson, was a violation of their Fifth Amendment due process rights. And the Second Circuit, in rejecting the procedural due process claim, essentially cited to the pre-Matthews cases and pre-Goldberg cases and said, by the way, we do not need to consider these cases given that tax is still evaluated on this kind of pre-1970s approach. But even if we were to evaluate the adequacy of the procedures in the tax context, we would find that the adequacy of post-deprivation procedures via filing a refund suit in federal district court or the Court of Federal Claims was sufficient. And it cited in large part the importance that courts have always placed on the government receiving the prompt payment of revenues. It also did note that there was an opportunity for an administrative challenge to the penalty, even though at the time, at least, there was some question as to whether the administrative challenge was statutorily required. So you have a very kind of difficult landscape in which tax is situated in this world. And well, what about notice? And we heard really from Susan kind of the in some ways shocking notice that taxpayers, or lack of notice that taxpayers receive. From a constitutional standpoint, as I mentioned, the Mullane case is kind of the benchmark or the starting point. There are a number of cases which have analyzed the adequacy of notice in the context of proposed termination of benefits, and how much information is required to be provided. And there's some really favorable cases that suggest that it's important that the agency take into account the context of the recipient, and that it is not fair to place undue burdens on the recipients to go find, to go search in, let's say, things like an Internal Revenue Manual to find out what an explanation code might be. So there is favorable case law, at least in the non-tax context. Not surprisingly, this case law has not really found its way into the tax system in light of some of the historical precedent I've talked about, right? In the tax system, notice the adequacy of notice is really generally thought of as only as defined through particular provisions in Title 26, which is the Internal Revenue Code. And while there are particular statutory provisions that dictate the what is required to be included in certain correspondence that the IRS sends, typically that the IRS's failure, and again, this is a little bit of a simplification, but the IRS's failure to comply with those notice requirements doesn't necessarily disqualify the IRS from action that is taken. It may have a minimal impact, let's say, on the burden of persuasion that the IRS might be required to satisfy if the case does go to court. So you have, essentially what this leads us to is due process not having a significant impact on the, or at least constitutional, due process, capital D, capital P, due process has a major impact. We do have, as Susan points out, we do have a strong adversarial process in our tax system, which is relating to deficiency procedures which generate to potential tax court review. We have, as Susan mentioned, this notion of summary procedures, summary assessment math error procedures, which provide significantly less protection. I mentioned, although for those of you who were on prior panels, we also have this whole world of IRS action prior to a return being accepted, the whole notion of what the IRS can do when a return is filed prior to it being processed. And that is in many ways really a black hole, which not only has obviously not been or not obviously, it has not been given constitutional kind of attention or protection, nor has it really received kind of statutory or congressional consideration in a meaningful way. So you have a process, a tax system, which from a benefits perspective is somewhat unique. We have statutory rights to notices. We have rights to prepayment and pre-assessment review, but there's a significant time delay before a taxpayer can benefit from that opportunity for judicial review. And as we know, in the context of certainly benefits that are essential to well-being, that time delay can have significant impact on the welfare of individuals. There is obviously, there is informal or impartial administrative appeal rights in the tax system, which provides some layer of protection against arbitrary or erroneous IRS actions. But again, those are informal and have not been viewed of as part of a due process protection. So what this means is we've really had very little impact or direct impact in terms of constitutional law protections, in terms of how taxpayers experience the IRS. Well, as we know, the world is changing radically, right? And in just a few examples, we see, on the bottom left of this slide, just in terms of how Congress is viewing the IRS and how Congress uses the IRS over the course of the last few decades, and as really illustrated in the course of the last couple of years with what the IRS has had to do in terms of delivering the economic impact payments. We see just an incredible reliance on the IRS to not just collect revenues, but to deliver not only benefits, but benefits that can mean the difference between living in poverty, making payments for rent, putting food on the table, and essential well-being. On the right of this slide, we see over the course of since the mid-1970s, we see a greater reliance on the tax system to produce benefits in the form of wage supplements and anti-poverty relief in the form of earned income tax credits, and that has, again, changes perhaps how we should think about the IRS in terms of how it's situated in constitutional due process jurisprudence. And of course, what has kind of generated the our being here today and in this series, as we see the increasing importance of the child tax credit and the importance of the benefits that the IRS is delivering these days, we question whether what the IRS is doing when it either approves or fails to approve or denies or terminates or reduces benefits, whether there should be additional notice and hearing right protections, and whether those protections should perhaps be warranted or justified under a procedural due process perspective. And so, there are a number of legal questions that we need to kind of wrestle with, and that I think courts will be wrestling with over the course of the next few years, that really relate to this overarching question is, will we see, just as we've seen in administrative law, a fading away of tax exceptionalism? Will there be a similar fading away of tax exceptionalism when it comes to constitutional protections? And I think that in light of the changing importance, or the importance of the tax system in delivering benefits, I think it's inevitable. And those questions include, is there a protected property interest when there is an application for tax benefits that is targeted to those most in need, right? And similar to, non-discretionary applications that arise in the context of non-tax benefits. And if so, if there is a protected property interest from a due process perspective, are the current procedures sufficient? I think, from what we heard from Susan's discussion, what we're going to hear, and we've heard in the course of these panel presentations, I think that the question really suggests an answer that one of which I think is there's an inadequacy in terms of protections that taxpayers experience or individuals experience when interacting with the tax system. But there is an open question in terms of whether constitutional law is a source of protection. And so I think from a matter of from a policy perspective, I really think that we need to kind of not necessarily rely on litigation, but one would hope that there would be legislation that provides for sufficient notice and hearing rights to protect those that are most vulnerable. And we're seeing those that are most vulnerable squarely situated in our tax system. And absent statutory or legislation around those protections, and we know how difficult it is to have legislation in today's environment, can the IRS and the tax court, can institutional actors learn of and apply best practices to ensure that they deliver to those that are really most likely to suffer from a potential erroneous deprivation, an erroneous delay, or an erroneous reduction in a benefit? And again, I hope the answer to that is yes, and that requires a broader perspective, which is one of the reasons why I'm so happy to have non-tax people on this panel to share the wisdom that, again, not to say that in other areas is it necessarily always a nirvana, but perhaps the tax system can learn from the best practices in other areas. And there are many potential solutions, and there are a couple of I suggest taking a look at Nina Olson has written a number of really interesting blog posts on procedurally taxing, and with suggested solutions, suggested approaches that kind of address some of the problems that arise from inadequate notice and inadequate hearing rights in these contexts, especially in the context of the expanded child tax credit. And some of these are more specific in terms of what the IRS can do in terms of notice and hearing. Others are more broader and systemic in terms of cultural and organizational changes. But it is, I think the time is ripe for a renewed approach to ensuring fairness when those interact with our tax system. And with that, I'll stop and turn it over to Jen.
Thank you very much. So as Jen shares her slides, so Jen is transitioning us into our non-tax context, but she'll lead us through some case examples of where SSI benefit recipients and child tax credit recipients sort of, move into the same space. So Jen, take it away.
Hi, everybody. My name is Jen Burdick, and I just want to thank Nina and the Center for including me today. I think this is a really interesting discussion. As people have indicated, I'm one of those non-tax lawyers who was very surprised to learn about the state of affairs in the tax system when my clients had to start interacting with it. So going to the next. Okay. So just to give you some context, I am typically a Social Security disability lawyer, and I specifically focus on representing folks who are seeking supplemental security income, which is the poverty program run by Social Security. And I bring that up because it means that a lot of the people I work with are the same people that we've been talking about all year in the economic impact payment stimulus context, and now in the child tax credit context, who are non-filers, right? These are folks who are very low income or have no income and have not had historical obligations to file taxes. Now, in the Social Security context, this is one of those benefit areas that is governed by Goldberg and the Matthews cases that Les just walked you through, where there is a lot of guaranteed procedural and substantive due process. It's guaranteed by the Constitution. And as a result, a lot of those principles are not only constitutional and have been won in litigation, but they've also made their way into regulations that dictate how these systems work. Now, we've talked about process and procedures due in a lot of context. I know I want to focus a little bit on the black hole that Les brought up before, and these are the people who are, perhaps in the tax system, after they've sought child tax credit benefits or whatever, but before a return might or may not have been processed, which is why I want to look at what happens to Social Security applicants. So, usually after I've met people, they have applied for Social Security benefits because they have some sort of disability that prevents them from working, or their children that have disabilities that prevent them from progressing in school or in other facets of life the way similar age kids might. And although the Supreme Court has not conclusively ruled on this topic, it's expressed support for, and a lot of circuit courts have found, that applicants for federal benefits enjoy due process protections. So that means at the moment that you file that application, there is some sort of assumption that there is some process due to you, even before you've ever been given benefits. And I've put some case law. The strongest case on this is Gonzalez v. Sullivan, which I added a cite for. So, taken from that context, I think a lot of people who interact with these systems expect that after they've applied for something, whether or not it's been processed, that there are some sort of procedures due to them. So in the Social Security context, what does that mean? That means if, my client has applied for Social Security benefits, even if they're going to be denied after they've submitted that initial application, they are due some sort of notice of that denial that is reasonably calculated for them to understand. Now, I've looked at a lot of cases over the last 4 days to understand what reasonably calculated means. At base level, it means that notice has to include broad reasons for denial. And I know this is something that Susan was bringing up when she was reading us the paragraphs from the math error notices. These notices are supposed to say on some level why your application is being turned down, even if it is you didn't submit enough information with your application, we can't make a decision, right? Like something like that. And they're supposed to spell out your right to appeal, when you have to appeal, and how to do that. So specifically, my client applies for SSI benefits, they're denied, they're sent a written notice in the mail, a paper notice. I think if they have an SSA account, they also get an email notice advising them of it. If somebody's denied because of like substantive reasons, like they do not think this person is disabled enough, it'll say, based on a review of your health problems, you do not qualify for benefits on this claim. This is because you are not disabled or blind under our rules. So that is pretty specific. They're saying you are not sick enough or you don't have a significant enough impairment to win. And they also will include a list of all the evidence reviewed, which is really important because you can see if they missed the main doctor, right, or something like that immediately from the very first notice they get. It explains the appeals process, that you have a right to appeal, where you send the form. In this case, if you're applying for disability benefits straight out, the next level appeal is to go for a hearing. and it highlights the deadlines, and it typically lists information about free legal assistance in your area. So in the Philadelphia area, like community legal services contact information is on that notice. The same for one of a few of our other organizations in the area. And so that is, you know, they are assuming that due process applies, and this is supposed to be a notice that complies with due process principles. You know, you can argue and quibble about whether it does, but you know, that's the intent, and this is what you get. Now, a couple more points I want to make this. So, you know, my client got this letter that explained he could appeal. He sent in his request for appeal, which entitles him to a hearing before an administrative law judge. This is usually in person, though right now during the pandemic, they're also happening over video and phone. The hearing is recorded, and the client can be assisted by counsel. And the client can also review what evidence SSA has received on his behalf and submit that evidence. Now, this process is an inquisitorial process. It is not adversarial. And I think this is really important in the benefits context. The Social Security Administration has a mandate that they are also supposed to be assisting the person applying with proving their claim. So this means that if someone is pro se or doesn't have assistance, or even if they do, the agency has an obligation to help develop the record. That means send out medical record requests if they're going for disability, and in some cases subpoena people if it's hard to get them. And people who are already receiving benefits and are getting terminated, or you know their appeal's been processed and they're trying to make a change, they get even more process, and that there's 2 levels of appeal typically. And I walked through that sort of process in a procedurally taxing blog, and I left a link below. But I wanted to focus on this example because it's more like somebody getting into the system, which is a lot of what we've been dealing with this year. So to contrast with, you know, what happens to my clients in the Social Security context, I want to talk to you about a few of the people that I've been working with that I've been trying to help navigate, you know, getting into the tax system to get child tax credits, and in some cases try to recover missing stimulus payments. So first I want to talk about a client, Mrs. A. She's 2 children who are 10 and 4 and who live with her. And I wanted to specify that because it's clear that this family has 2 children that would qualify for the child tax credit because these are dependents who live with her full time. She took steps to inform the IRS about her children. And in this case, the IRS has confirmed that they are aware of this relationship. And we know this because she received all 3 stimulus payments for herself, as well as the dependent stimulus payments for her children. So somewhere within the IRS, they know she has these children as dependents, and these dependents have been recognized as children who she supports, and they've given her money. You know, first the $500 for each with the stimulus payment in 2020, then the $600 for each with the newer stimulus payment that came out at EIP2 that came out at the beginning of 2021, and then again for EIP3, right? All 3 of them. She actually did file her tax return, and we know it was processed, at least to a certain extent, because she received a refund, right? And she's not got a single advanced child tax credit payment, not a single one. She didn't get it July, August, September, October. I know Les had a slide showing you all the different places, all the, you know, it's a monthly benefit that everyone's supposed to get, but she did not get a single one. So let's talk about the notice. She did get one notice from the IRS, and the IRS publicized that they were going to send a notice to all the people who they expected would be eligible for the child tax credit. It's called the 6416. I pulled off a sample copy over here, and it both indicated that you might be eligible and it estimated the amount you might receive. So she did receive that. But since then, she has not received any other notice from the IRS about the advanced child tax credit at all, just none. She's not getting them, and we have no idea why. She also has not received any notice about any steps she should take to redress this. However, Mrs. A, you know, she likes to take care of things. So she's taken a lot of steps on her own, which, you know, I want to highlight is not typical. You know, a lot of the people I'm talking to who are not getting the child tax credit are also not in a situation in their life where they can spend a lot of time trying to figure this out. You know, perhaps the parent has a disability, that's a lot of the folks I'm talking to, or, life is stressful, they have kids, things are happening, like this is just not the focus of their time. But Mrs. A spent a lot of time working with her congressional representative. A constituent service representative contacted the IRS, and the IRS could not explain to them what happened. She came to Legal Aid for help, and now she's co-represented by us and Philadelphia Legal Assistance. And we tried to help use one of the IRS tools that's on their website, the Child Tax Credit Update Portal. Now, this is a pretty challenging process because to get in there, even to just check your status, you need to get through the ID.me software, which can take a long time and requires people to come up with lots of documents that perfectly match lots of other documents. So it took us an hour and 40 minutes just to get through that. And then it listed her child tax credit eligibility as pending. No other explanation. So we pulled her tax transcript. No obvious reason she's not getting it. And when I called the IRS practitioner hotline, they first wouldn't answer any direct questions about the child tax credit. They try to push you onto a child tax credit line where you can't get individualized information about her case. And the only issue that we can come up with on her return is apparently she's flagged for her return to be adjusted for unemployment compensation. But that shouldn't necessarily hold up her child tax credit payments because she's obviously eligible based on her income level. And as she could tell by unemployment compensation, she's not currently employed. So next steps. We know that, she will probably be able to claim the missing benefits when she files next year. But as someone who was getting unemployment that has stopped because pandemic unemployment relief has stopped, this is a family who could have really used this relief this year and is less highlighted. And I think we all know that, low-income families, getting this money timely is very essential to well-being, is actually part of the purpose of this whole program, right? The idea is to smooth income so families can depend on it. But from a due process perspective, one of the problems is, unlike my clients who applied and then immediately got some sort of notice back explaining what was happening, she never received any notice. She had no idea what she should do or where she should go. There are no procedures that would allow her to complain, protest, or even appeal the fact that she hasn't gotten the first 4 advanced child tax credit payments. Even the Taxpayer Advocate Services website says they're not going to assist people with this because I think there's nothing that can be done, except they have created a very helpful worksheet to help people keep track of what they've missed so they can try to recover it next year. And that's just kind of where it's at. So from a due process standpoint, if procedural due process existed here, I think it would be hard to argue that this was adequate. She just doesn't have any idea what's going on at all with her case or why she hasn't been getting it. But I will move you to another client example I have. This is an SSI recipient who has 4 children living with her, 4, 13, 15, and 17. So that's 4 children who should be eligible for the child tax credit based on their age range. And because she's an SSI recipient, that means the maximum income she can be receiving a month is $794. So she's clearly eligible to receive the child tax credit. She received the stimulus payment for herself, but none of the EIP dependent payments for her children. So unlike Mrs. A, I immediately know that she hasn't taken any steps to tell the IRS that she has these children, right? So this is a slightly different scenario. And she didn't do that because, like many SSI recipients, she didn't realize she could receive stimulus or advanced child tax credits for her children, and because she believed that as an SSI, like a non-worker, that she wasn't eligible for tax refunds until we actually reached out and informed her of her rights. So we helped her complete the Get CTC app, which is one of the simplified tax return apps that were available for non-filers to claim her 4 children. Now, when you fill out this app with someone, they're putting their information in real time, and you get an immediate response if you're using the Code for America Get CTC app. It's a little bit more delayed through the IRS's non-filer portal, but immediately she got a rejection text via text, which she opted for. They give you a choice of text or email with a code that you could look up the IRS website, meaning that one of the children on her return was already claimed. But on the Get CTC app, she also then got a very detailed, plain language response explaining what was happening, which is that her claim would be rejected because one of the children is already on another return. So somebody else has claimed one of her children. And then it's actually pretty substantial. It explains that if you want to receive one of the payments now, you can remove the dependent from your tax return and resubmit it to the IRS. But if you do this, you would not get the child tax credit or the stimulus check for the other dependent that was on the return, but you will get any other credits you are eligible for, including payments for yourself and other dependents. It also, gives her the option to whether or not she wants to resubmit and remove the person. It also gives you more information on what to do. If you think the family member or guardian who mistakenly claimed your dependent, perhaps you can work it out directly with them, which is not typically the kind of advice I give to clients, but I have to say with the child tax credit, asking people to, instead of relying on the IRS, to go back into internal family situations seems to be one of the only recourses people have, because in a lot of cases, maybe a child is on someone else's return because you used to live with someone else, or, there's all sorts of circumstances that could lead to that. It also explains that one of the ways you can contest that is you have to mail a paper copy of your return to the IRS. And explains that this process can be difficult and time consuming, but this is the process. So this is actually a fair amount of information that Mrs. T got immediately upon using this app. She knows the problem with her application, and she has several ideas for what next steps could be. So we were able to register Mrs. T to claim one of the 4 children living with her, which she opted to do, and she is getting the CTC payment for that one person. What's interesting about notice is she never received the 6416, that letter that I told you about with Miss A, with the IRS sent people they thought were eligible. But again, that makes sense because she is never filed taxes in recent years, and it's not clear that IRS knew about her relationship with these children. What's also interesting, though, is since filing the Get CTC app and starting to get her child tax credit payment, she hasn't received any notices at all from the IRS about the claimed child or the other 3 she could not claim, even though at this point, presumably, somebody has some information that she's trying to claim these other children. But she will, under the American Rescue Plan, at least get a letter in January, that's what the legislation promises, that will indicate how much advanced child tax credit payment she has, so she can use it when filing for the other half of that payment next year. I also noticed here, Nina mentioned in a recent blog post, the same one highlighted, like, Les, I have some questions, like, do the communications that she received over text message from the Get CTC app regarding the children constitute notice? Would that be reasonably calculated notice? And what do we think about the hearing or other recourse? Right now, Ms. T now knows she can file a paper return to seek the other 3 children, or file the complete CTC payment on her 2021 return. Either way, we know that she's going to have to take some action to get access to the child tax credit for the other children. We don't really know what that is yet. And it's possible this will occur over correspondence, which Susan explained is kind of the norm. And just from all my interactions with Ms. T, but I will just make clear, that's not going to be a process that Mrs. T is going to be able to engage in, right? She didn't even know she could file for these things. Literacy, she's not quite illiterate, but she's fairly close. So it's unlikely that if she was to get a lot of letters from the IRS saying, well, you need to prove that these children live with you or whatever, that she would be able to do that on her own. But this does making me think a lot about the role of apps in notice. Les talked, or we've talked a lot about, what notice is and when notices are due. One thing I wanted to highlight is the Get CTC app created by Code for America is providing much more significant information and notice than the IRS Nonfiler portal did. So that portal, which came down in October 15th, had a similar setup where people were applying online for simplified returns, and they would not immediately, but in usually a day or two would get an email explaining whether their application was accepted or rejected. But unlike the Get CTC app scenario, if you got that rejection, it would just give a code, right? It was just a code that if you want, there was a way on IRS website that you could look up what that code meant, but that did require a level of decoding, which, is a little complicated. And it is a lot easier. You think if there could be a code there could also instead just be an automatic paragraph in plain language explaining what that code meant. Like, was it dependent on another return, or was your social wrong, or any of the codes that Susan was talking about earlier. There's a lot of reasons why these things weren't being accepted, but a lot of people didn't really know what to do with the rejection codes. And I was very pleased to see the Get CTC responses having like a little explanation of what those codes meant, which also meant that people didn't necessarily have to have technology to get to the IRS website to, pull up the codes and go through them. I mean, that's a lot of steps. But they've also been thinking a lot about how do we classify these communications? Are they timely? I mean, they're really fast, so I'd argue yes. Are they adequate? Well, that's an interesting question. I would argue that the Get CTC app notices are probably a lot closer to adequate than the IRS Nonfiler portal codes. But I do think, there is a lot of discussion in the due process context about, the role of using text messages and emails instead of paper notices as a way to give people notice. Is that enough? Do we need it to be in the mail? And that's, I think something that warrants more discussion. I think for certain people, emails are probably better than mail because they won't lose them. But there are some people who really benefit from having that piece of paper, particularly if they're going to take that piece of paper to somebody else to review it. So I also want to just take a minute to talk about FAQs. FAQs have been used pretty liberally in the EIP and CTC. So just wrapping up, there are a bunch of FAQs out there. One that I thought was interesting was on October 15th, the IRS issued an FAQ explaining that they had a tech issue that meant that they sent didn't send some people CTC payments or sent them incorrect payments, and they were going to send them a notice to explain it. And it just made me think that if you're sending notices to these folks who didn't get the right amount, what about all the other people who applied for CTC payments and aren't getting them? So just something to think about. And I can turn it over to Manasi. Thanks so much.
Thank you, Jen. And we can take a look at the new proposed legislative language if there's time at the end. But yes, if we can shift again over to Manasi, who will talk about Social Security disability and what closing of offices looks like.
Great, thank you, Anna, and thank you, Nina, and the Center for having me. I have the distinction of being neither a tax person nor a lawyer, so I have learned a lot today already from the other panelists. I come at this question as an economist, and I study kind of optimal design of the social safety net, and part of that is thinking about administrative burden or the hassles associated with applying for programs. And so today I'm going to talk about that in the context of the Social Security disability program, and at the end I'll also summarize other evidence that we have on the effect of administrative burden on the take-up and targeting of social safety net programs. Okay, so in kind of the economics field, there are some competing theories about administrative burden and how they affect take-up and targeting, right? So we in general would expect that administrative take-up of social safety net programs, but a lot of recent empirical work in economics has tried to understand the effects on targeting, not just overall take-up, but who is most or least discouraged from taking up as a result of administrative burden. And so there's kind of some competing economic theory here. On the one hand, right, you could argue that maybe these administrative burdens screen out people who are least in need. If we think about the administrative burden as kind of a time cost, right? And if the opportunity cost of applying for a program is highest for people who have other opportunities, right? People who in general have a high socioeconomic status, then we might expect these administrative burdens to screen out people who don't need the programs that much because they're going to choose to do something else with their time. On the other hand, right, we could also write a model that these administrative burdens screen out people who are most in need, right? And especially if we come at this from a behavioral economics perspective, where the people who are most in need might have difficulty, especially with hassles that require a lot of cognitive capacity, or they're primarily, cognitive in nature, but even in terms of time costs, right? If you think about somebody, a single mother who can't easily take time off of work, even those time costs could end up screening out people who actually need the benefits the most. And so this is ultimately an empirical question. And so that's what I'm going to try to study today in the context of the Social Security Disability Program. This is from a paper from 2019 that was joint with UALE. And I'll also summarize some evidence that we have in the context of other social safety net programs. Okay. So in particular, I'm going to talk today about the closings of Social Security field offices. So there have been about 120 closings over the last 2 decades around the country. And this has to do with administrative burden because, of course, Social Security field offices are places where people go to get help with their disability application, right? And so if your neighborhood Social Security field office closes, you either have to go to the next field office to get help, or you have to figure out the application yourself, or you have to find some other kind of assistance with the application. Okay. And what's, I think, important here is that oftentimes we think about the disability determination process as being the primary screening mechanism for the disability program. But as we've heard throughout today, right, the application process itself and the interaction with the agency, even prior to the disability determination process, might screen people into or out of disability. So in particular, if you have individuals with high severity conditions who are discouraged or deterred by a very complicated application process, right? There is not really, for example, a universal health database where we can identify those individuals and either automatically enroll them or encourage them to apply, right? And so the application process is especially important in a disability context where we don't have administrative data on who is going to be eligible for this program. And then on the other hand, right, we might want to make sure that people who aren't going to be approved don't apply, because we also have evidence that people who are ultimately rejected from disability benefits have lower earnings later after they're rejected, in part because they've been waiting for so long and been out of the labor force for so long, right? So on both sides, both in terms of encouraging those who are likely to be allowed and discouraging people who are unlikely to be allowed, we want to perhaps design an application process that's well targeted. Okay, and then also disability applications have a very high administrative cost because of the cost of reviewing applications. So I'm going to ask in this paper, we're going to ask how Social Security field office closings affect disability applications and awards, and in particular, who is discouraged as a result of these closings. And we're going to do this using a difference in differences strategy based on variation in the timing which these field offices close. And we're going to use detailed administrative data from the Social Security Administration on applicants and field offices. Okay, so we'll talk about those methods in just a second. So just briefly on the data here, we have a lot of data from the Social Security Administration. So in terms of field offices, we see field office location and their closing date. We have data on walk-in wait times, field office staff, and Social Security card issuances. We also have data on calls that are made to SSA's 800 number by area code. So I'll show you some evidence from all of those pieces of data. We also have a lot of information on the applicants. So from the 831, we have disability applications between 1990 and 2015. That's going to include, the date of the application and then some key demographic characteristics like age, type of disability, the severity of the condition, and education. And then we also have from other places location, and as well as whether they have legal representation, whether they filed online, their primary language, and then their pre-application earnings. Okay. And then we use some publicly available information on their location. Okay, so the way that Social Security disability works, this is a very stylized figure, right, is that the offices that we're talking about in this paper are these local field offices, right? So these are offices that provide assistance with the application. They process the application. They then send it to a state disability determination services office, which is going to make the initial decision about whether somebody is allowed or denied. And then finally, if somebody is rejected, they can appeal that decision. Okay, so field offices do a lot of things, but disability claims are a big part of what they do. And what we're going to do in this paper is study 125 field office closings that have happened since 2000. And these were mostly driven by federal budget cuts. So there are now about 1,200 Social Security field offices in the United States. And when an office closes, the staff from that office are usually reassigned to neighboring offices. And I'll show you some evidence. I'll talk about some evidence on neighboring offices as well. And so the method that I'll use here basically is the idea that we're going to use offices that close in the future as controls for offices that close today, right? So what we find empirically is that places that experience a closing are different than places that don't experience a closing, but we can compare within places that experience a closing just by exploiting differences in the exact timing of the closing. So this is just a graph of when Social Security field office closings have happened. So you can see that there have been, this is the 125 between 2000 and 2014. About half of them have happened since 2010. And then this is a map of Social Security field office closings. So the red diamonds are offices that have closed, and then the blue stars are offices that remain open, right? So you can see that these closings are in many different parts of the country. Some of them are clustered in particular areas like New York and Los Angeles, just because there are a lot of offices in more populated areas. This is just a zooming in on the state of New York to show you kind of what we're going to do in this empirical strategy. So what we're going to do is we can classify zip codes by whether their nearest field office closed, right? So if we take this field office closing, for example, we're going to say that your zip code experienced a closing if your closest field office closed. And then we're going to call these orange zip codes neighboring zip codes. Neighboring zip code means if the field office that is near your closest field office closes, then you're going to be considered a neighboring office. And basically what we're going to find is pretty large spillovers to these neighboring offices, that even these neighboring offices that remain open experience large effects because they become more congested as a result of the closing of one field office. Okay, so just to show you some raw results, just from the raw data before doing any kind of adjustment. So what we have here is in the solid line, we have the treated zip codes. So those are the zip codes that experience a closing. You can see that there is a fairly large decline in a number of applications following the closing. Whereas if we look at our control zip codes, we don't see any decline at the same time. We just see a secular increase in applications for those control zip codes. Now we can apply regression adjustment. So I won't get too much into this. This is kind of a standard difference in differences framework. But basically all we're going to do here is we're going to take some outcome like the number of applications, and we're going to regress it on zip code fixed effects, state time fixed effects. And then the most important thing here is that we're going to regress this on whether you are a treated zip code, so whether your closest field office closed, times dummy variables for the year in which the closing happened. Okay. So basically what I'm going to show you in all of these graphs is these delta taus. The delta taus are going to give us the difference between the treated zip codes and the control zip codes in, for example, the number of applications based on the year relative to when the closing happened. Okay, so the first result here is that disability applications fall substantially when field offices close. And again, right, the idea here is that your field office closed, it's now harder to complete this disability application because you don't have the assistance, right? Getting back to administrative burden. And as a result, we see a large drop in the number of applications. This is a 10% drop in disability applications in areas surrounding the closed field office. So this is a very large decline in the number of applications as a result of the closing. One thing that we're going to be interested in, again, getting back to this discussion about targeting, is not just the fall in the number of applications, but also what happens to the number of allowances, disability allowances, right? It might be the case that we just end up discouraging people who would have been rejected from disability anyway. But that's not what we find. What we find instead is a large decrease in the number of allowances. So we find a 16% decrease in the number of disability allowances, which means that it's not that these field office closings are just discouraging people who would have been rejected. They're actually discouraging disproportionately people who would have been allowed onto the program if they had applied for the program, right? And so that's important here for in terms of thinking about who is being discouraged from applying. It's people who would have been found eligible for this program. And then I just want to show you results by the type of program. So this is maybe, probably consistent with your priors. We find larger effects for the SSI program than for the SSDI program. That might be for a number of reasons. One is that the SSDI application is more easily can be completed online more easily, and it might also be about differences in the education of the population as well. Right. So this is for SSI adults. So we see a 14% decrease in the number of SSI adult applications as a result of field office closings. Very similar for SSI child applications. We find a 15% decrease for SSI child applications. So these are very, very large effects for the SSI program. In contrast, for the SSDI program, we still find a decrease, but a smaller decrease. So we find about a 7% decrease in the number of SSDI adult applications. Okay, so we do a number of things. I'm not going to, in the interest of time, I won't get into all of these, but we look specifically at different types of observable subgroups. So we look at individuals by a certain measure of the severity of their condition. We look by disability type, and then we also look by socioeconomic status, in particular education and pre-application earning. So again, we're interested not only in the overall effects on take-up, but also on particular subgroups. Okay, so I won't get into these results too much. On severity, what we find is a kind of complicated picture. What we find basically is that the people who are least discouraged are the people with the highest severity conditions and the people with the lowest severity conditions. And what you end up doing in closing these field offices is really discouraging people in the middle of the severity distribution. And we did a lot more work to understand this result. So I'm happy to talk about it at the end if people are interested in it. When we look at type of condition, we don't see a lot of differences. We see some differences by type of condition, but these differences are not statistically significant. We do find big differences by socioeconomic status. In particular, when we look at education, right, people with less than a high school degree, the discouragement effects are much larger for them than they are for people with a college degree, right? Which is what you might expect if we think that someone who has a college degree has more capacity to figure out the application on their own, has more financial resources to seek assistance elsewhere. What is really happening when these field offices close is that they're discouraging people with lower levels of education from applying for the program. Okay. So let me just talk briefly about some channels here. Right, so there are a few different channels through which these field office closings could affect applications, and this gets a little bit to this broader question of how administrative burden affects take-up of social safety net programs. So one possibility is this is operating through congestion at neighboring field offices. So this is a quote from a writer in The Atlantic who's trying to apply for disability benefits for her daughter. And she talks about how crowded these field offices are, how long she has to wait both in person and on the phone. Okay, so that's an example of congestion. Another possibility is travel time to neighboring offices. When your closest office closes, right, especially if you don't live in a large city, you might be traveling a long time to get to the next office. And so that's another possible way that these office closings might affect who ends up applying. And then finally, program information. If these offices are providing information to people, it's possible that people are just less familiar with these programs when the office closes. So just a little bit of evidence on each of those channels. So we can look at walk-in wait times at field offices when these offices close. So this is basically the walk-in wait time for the neighboring offices. And we see large increases in walk-in wait times at neighboring offices when your local Social Security field office closes, right? So basically these neighboring offices are becoming more congested. People are waiting longer in person, they're waiting longer on the phone, and that might be driving some of this decrease in applications. We also look at travel time to neighboring offices. So we use some data from Google Maps to do this. Okay. We find actually relatively little variation by the distance to your neighbor, okay, which is I think was a little bit surprising to us, but we don't find that travel time matters a lot. What we find here is that it's mostly congestion in the neighboring office that is driving these decreases in the number of disability applications. Okay. In terms of information, there's not a lot that we can say about information, but one thing that we can do is we can look at calls to Social Security's 800 number by area code. And what we find is that when these offices close, that essentially calls to the 800 number increase from the areas where the Social Security field office is closed, right? So this suggests that people are using the 800 number to seek information in the absence of information that they would get from their field office. Okay, so I'm going to skip this. I'm going to skip this decomposition, but as I mentioned in the decomposition, basically what we find is that this is mostly attributable to congestion at neighboring field offices rather than travel time or information. Okay, so finally, I just want to summarize some evidence from other programs. So from the SNAP program, Finkelstein and Noto-Adicto did a field experiment of providing information and assistance to people who were eligible for SNAP but hadn't taken it up. They find an increase in enrollment and in particular for higher socioeconomic status individuals. So kind of the less needy individuals. On the other hand, when studying kind of the recertification process, other papers have found that recertification costs reduce enrollment, and that's especially among lower SES individuals. Okay, and in terms of Medicaid, there have been studies on the effect of automatic enrollment, that this increases enrollment, especially among younger and healthier people. But so Derek Wu has a very nice new paper from Indiana, where Indiana automated several, basically automated several enrollment in several programs, SNAP, Medicaid, and TANF. Sorry, when I say automated, they outsourced the enrollment to a private company that was trying to automate this system, but basically it was introduced a lot of complexity into the program. And he finds that complexity discouraged people from applying, and especially discouraged at the initial enrollment phase discouraged higher SES people, but at the recertification phase discouraged lower SES individuals. Okay. In terms of EITC, I think we have less evidence here, but there is one paper from 2015 that did a field experiment of reminding people who seemed to be eligible for the EITC but hadn't taken it up, and they do find an increase in EITC take up, and that was mostly among lower SES people, the reminders. encouraged lower SES people to take up the EITC. And so some of this evidence, as you can tell, is kind of conflicting, right? On the one hand, some studies find that the marginal enrollees are lower SES, others find that they're higher SES. And so one potential explanation for this is that the effect of increasing administrative burden depends on the baseline level of the burden. So with these papers, if I have to synthesize these papers, I would say papers tend to find that if the baseline burden is low, that the additional burden discourages relatively high SES individuals. Whereas if the baseline burden was already high, then you're really going to discourage people maybe that you want the most on this program, low SES individuals. All right, so let me stop there. And thank you all for the time, and I'm happy to talk more.
Thank you. That was really interesting and honestly a little frightening of how I'm just thinking about congestion and the upcoming filing season with all these non-filers sort of coming back into the tax system. But I believe, Les, you have a comment.
Well, I mean, it's fascinating research. It really suggests that the close connection between kind of the concept of administrative burdens and the underlying concerns of due process, which both of which get to, one of the concerns of both is are there barriers to, or that might suggest an erroneous action the government is taking, or and it really kind of relates to as well sometimes things that are kind of outside the court's power to necessarily kind of fix things, and so many outcomes are dependent upon agency policy choices. And I know from the IRS has over the last couple of decades really reduced the availability and numbers of walk-in sites for taxpayers. So the opportunity to receive in-person assistance has just has decreased in absolute terms, and also in the ability to kind of walk in. I think you need to have appointments now, and it's just fewer opportunities to get personalized service, let alone we all know the challenges of reaching the IRS on the telephone.
One thing that I've been thinking about, this goes to, there are a couple of points that have come up through all of these presentations. One is so much of the litigation is about termination of benefits. And so what you've got in the tax system is applying for benefits first, and so that's an interesting, where does due process fit in? Is there less of a concern if you apply in advance and then you get this second chance in the tax system to claim it on the tax return? And I think we had some lessons from the earned income, the EIPs in that regard. But then the second thing is, the point that Jen made about inquisitorial versus adversarial. And what we've got in the IRS is very much the minute that you engage with the IRS and put in a return, it quickly turns adversarial, which, as opposed to Social Security, where there's, as Jen described it, a mandate that they are to assist someone in gathering this information. And that's really got me thinking about how the IRS, if you created a family and worker benefit unit, FABU, if you created FABU, how would they interact with someone who's applying for the advanced child tax credit, and what could they do to assist that? And then the last thing is sort of Manasi's point about, the impact of just the kind of assistance that is available, and then the presence of that assistance. And as we know, in the IRS, even though it affects many more individuals than Social Security does in any given year, it has 396 walk-in offices. That's astonishing. And I just, it really makes, I don't know where that fits in under constitutional due process, as opposed to just thinking about due process and administrative burden in a more lay way. If the purpose of your, part of your job is to get these benefits through the tax code out to eligible individuals, what are you doing to do that?
Nina, I'm going to defer to you on this one. If we want to go back to Jen and look at some of the language that the new language from Ways and Means, or if we want to just stick with questions and have Jen's slides available.
Yeah, the thing about the language, we were going to discuss the original, the Ways and Means mark and some of the language that they had to give some kind of dispute resolution during the year. And I think it's instructive to look at that. But we also need to note that the most recent version of Build Back Better eliminates all of that language. And I note that the IRS had said, early on that by September or so, sometime in the fall, there would be an option to add to the CTC update portal children who were born during the year. And that ultimately, and we have not seen that option yet, which means that they're facing some technological challenges. And there's certainly no option for, posting a claim saying that, no, these children are with me. And that language is now taken out of the Build Back Better language to put that burden on the IRS next year if the advanced child tax credit even continues for one more year. So I don't know, Jen, whether you want to take a moment to, share your screen again and go to those slides so we can look at what was proposed and what some of those things raise. I guess the good advantage is, we have more time to really hammer out what needs to be available to folks.
So here is some of the language from the House Ways and Means proposal where it directs the Secretary to create procedures to expeditiously adjudicate competing claims of presumptive eligibility for the same child. And it indicated that this must include an expedited process. This is a very, as well as procedures to appeal an adverse decision. I mean, some of the things that were interesting, and as Nina noted, this is not in the most recent proposal, but what was in the House Ways and Means proposal really only focused on creating a dispute resolution procedure for the circumstance where two people were trying to claim the same child, nothing else, like not for a situation where you just weren't getting it and you weren't told why, or we're working with someone else right now who's just getting the wrong amount, no explanation, just the wrong amount. Her child is under 5, but she's getting $250 instead of $300. Not what sort of process is provided, whether this expedited process would be over correspondence like the IRS typically uses, or would include a conference or a hearing, either in person or over the phone, who's a decider, how to do other things, whether there's any indication this would be inquisitorial, but it was something.
It strikes me that in thinking about it from a due process, from a procedural due process perspective, so much of the way the courts think about it is context specific, and we think about the things that we don't know and what could improve. Perhaps it suggests that there should be a different approach for certain taxpayers, certain individuals who perhaps were previously non-filers, or for those who have incomes below a certain threshold. So we're talking obviously about heavy lifts for the IRS to perhaps create new procedures or new notice, but maybe this should be thought of in the context of those most vulnerable need more protection, and perhaps that could be a starting point in terms of how the IRS and perhaps Congress thinks about what is required to be done to make the process fair or more consistent with due process norms.
I had a question, and this will sort of transition us into the next workshop, but as we talk about the IRS increasingly becoming a benefits administrator, an anti-poverty program administrator, and this is a question for any of the panelists, do you see or anticipate any legislation or litigation that will sort of challenge the less what you were talking about, the sort of post-deprivation treatment that we are seeing. Do you think that the shift in sort of the unofficial mission of the IRS will lead to any change in how the IRS views itself in the due process space?
I mean, I think yes. I think we've started to see some of it already in the context of the EIP litigation. So there's some interesting analogous issues that were presented in some of the EIP litigation, including some opinions that are out there that have framed, for example, challenges to the IRS's denial or the legislation denial of EIP benefits to certain classes of taxpayers. In order to get jurisdiction, some courts some claimants used, rather than seeking refund procedures, sought subject matter jurisdiction through something known as the Tucker Act, requiring there to be a money mandating statute. And there were a couple of opinions which basically framed the EIP, which is really in the context of the fiction of a refundable credit, and looked at the legislation as creating a statutory right to a payment in a manner that allowed for a cause of action outside normal refund proceedings. And I think that approach that courts have taken in the EIP litigation is really helpful, potentially for arguing that benefits administered in the tax system are a protected property interest for due process purposes.
Thank you. Dylan has a question or comment, so if you want to unmute yourself, you can go ahead and ask.
Sure, thank you, Anna. Sort of a question for Jen. I am not in the field of, SSI, SSDI, and so forth, but done work in terms of taxes as well as other more traditional welfare programs, and sort of curious of your experience with, community-based organizations and how they sort of help you in your outreach efforts and education efforts and so forth, and kind of thinking about that in the world of tax as well, that we know from other sort of research and evidence that the role of trust, the role of really community-based organizations understanding the sort of concerns and context that people in the community are encountering, and how they can sort of help people navigate these more complex systems. So just kind of curious, like, how has that kind of been in your work, and if there's anything we can learn from that?
And that's a really good question. And I think the role of trust here has been huge. As I said, particularly, with the folks I see, SSI applicants have been told, or recipients have been told for years, that not only do they not need to file taxes, but they shouldn't. And early, when we first found out that the CTC was coming, we were trying to get a lot of those folks to go and file taxes so that they could sign up with the IRS to get these payments. And even tax volunteers through VITA services initially would be like, why do you want to file? You don't owe anything. Nothing's owed to you, because these were advanced credits, right? And that created a lot of suspicion and concern. And I know, at least for me personally, I've had a lot of detailed conversations with my clients about why they need to file taxes now and why it is safe, and explaining the changes. And I have been hearing from other people who've been having similar conversations in the field. One thing we advocated for a lot, and we were very lucky to get, and I can try to put it in the chat later, is there's an FAQ that makes explicit that community helpers who are not tax professionals can help people sign up for these payments, which has been really helpful. We've done a lot of trainings with social workers and case managers who already have pre-existing relationships with people in the community, who can talk them through, what it means to sign up to get missing stimulus payments or child tax payments, which I think is a really big deal. But I will say that I don't think the problem is solved. I think this continues to be a large issue. I think a lot of people are very scared of the IRS, and for some of the reasons Nina highlighted, of it being an enforcement agency and all this perceptions that if they make a mistake, they'll get in trouble. So I think it's something that there's not a perfect solution yet, but there's a lot of interesting conversations about how to do outreach to populations who haven't been brought into the tax system before. And I think you know, as more of these protections get built in, if they do, I mean, the other side benefit is I think people will be more comfortable, because I think for folks who have signed up this year and had these bewildering circumstances when they're not getting what they're expecting to get and they don't know why, that doesn't help, right? That kind of exacerbates the concern that they're not doing the right thing or something is wrong or they're going to get in trouble.
In our next session, we're going to hear from some folks who have been involved with Affordable Care Act, you know, navigators, to talk about reaching out to that population. And we're also going to hear from a former director of Social Security research and evaluation to talk about some of the things that, you know, about trying to change the culture of the organization, or even a culture of an organization that has a mandate to be inquisitorial, as opposed to an organization that has a mandate it perceives to be enforcement oriented and adversarial. So I think that leads very well to the discussion that we'll have next week on how do you actually change the culture of an organization that really needs to be changed if it's going to continue to administer not just the child tax credit, but administer the credits it already has in the code that are not going anywhere, like the premium tax credit and the earned income tax credit and the American Opportunity Tax Credit and the existing child tax credit. And so unless others have questions, with that, I want to thank Anna for moderating the panel. And I want to thank all of our panelists for getting on the record and really laying out here, you know, starting from very specific, you know, Susan going through math errors so that everybody understands what these procedures are like and what people face. To Les really laying out a very high level discussion, but a very, very important discussion of what due process constitutes and where it fits into the tax world. To Jen sort of showing what another agency does. And then Manasi, you know, really highlighting what the impact of administrative burden can be, and then coming back again to what's the interaction between administrative burden and due process. This has been a terrific panel, and I just want to thank everyone who stayed tuned for sharing it with us. And we'll get those slides out so everyone can see them. Thank you all very much.